Good morning. Let's get right into it. We have this bill, the text, the language is here. Let's dissect it. Let's really just go into it and see who's included, who's not, the terms, the fees to be paid. In summary, we already know dreamers are included. We already know TPS holders are included. And essential workers are included. So let's go into it and see the terms, and hopefully this bill will pass and it will become law so that we can start processing those green card application or residency application or lawful permanent residency application, of course. Let's get into it. Okay, so lawful permanent residence for certain entrant. Okay, and adjustment of status for certain entrant. And what is it that I kind of highlight the main points, because there's a lot to talk about, but kind of highlight the main point. Okay, so in general, notwithstanding sections 201, 202, 203, and 245C, and subject to subsection C, the Secretary of Homeland Security shall adjust to the status of an alien lawfully admitted for permanent residence, an alien described in section B, if such alien, okay, that's the condition, submits an application for adjustment of status in accordance with procedure established by the Secretary. What are this procedure? In addition to any administrative processing fees, remember we have fees for the green card, which is $1,225. That includes the biometric. So in addition to those fees, the alien or the entrant must pay a supplemental fee of $1,500. So that's the penalty fee, $1,500, and complete the satisfaction of the Secretary, security and law enforcement background check, and then any medical examination consistent with section 221D. Remember, now they require the COVID-19 vaccine as well as part of the medical examination requirement. Okay, and so now who's included? An alien who has been continuously physically present in the United States since January 1st, 2021, was 18 years of age or younger, those are DACA recipient or dreamers, on the date on which the alien entered the United States and has continuously resided in the United States since such entry. Okay, for DACA recipient dreamers 18 or younger, physically present since January 1st, 2021, and has continuously resided since that entry. Okay, then demonstrate a record of honorable service in the uniformed services of the United States, attainment of or completion of at least 2 years in good standing for a program lending to a degree from the United States institution of higher education, or post-secondary credential from an area career and technical education school in the United States. Basically some type of education, either post-secondary like a technical type of education, or a associate degree 2 years, or a higher education is one of the requirements as well. And then during the 3 periods immediately preceding the date on which the alien submits an application for adjustment of status under this section, a consistent record of earned income in the United States or enrollment in a program described in clause 2. So 3 years preceding this application, pretty much I believe that's when people will be able to apply for the actual green card, the way I read it. Then at that point, the person has to show a consistent record of earned income in the US, or that the person is admitted to some type of technical post-secondary education, or some bachelor degree, so it's in a program of education. That's what I'm trying to say. So, and then we have current employment or participation in an internship, apprenticeship, has been continuously physically present in the United States since January 2021. So now we're going to essential workers, right? The first one, they're really talking about the dreamers, DACA recipient and dreamers. Now we're talking about the essential workers. They say that has demonstrated a consistent record of earned income in the United States in an occupation described in a guidance of the Department of Homeland Security entitled Advisory Memorandum on ensuring essential critical infrastructure workers' ability to work during the pandemic. So basically, you have to demonstrate a consistent record of earned income. You have to show that you've earned income. And you've been present since January 1st, 2021. How consistent it is, I don't know, but at least you have worked, okay, for the period on January, when the pandemic started, right, from January 31st, 2021 until August 24th, 2021. Sorry, the pandemic, when they started pandemic, January 31st, 2020 until August 24th, 2021. You have to demonstrate a consistent record of earned income in that in the field that they call essential worker, as defined in this memorandum. Remember, we've talked about essential workers before, and if you go into my community tab, you will see how we have what they call essential workers. Really, the list is long. You can check and see, but most importantly, you have to demonstrate that you earn income. So you got paid. How? Show proof. That's what they really want. And then that's the essential worker has been continuously physically present in the United States for not less than 3 years. Well, as of really, this is, it gets confusing, right? They say you have to be present as of January 2020, January 1st, 2021. But in order to meet the requirement of essential worker, you have to be living here for not less than 3 years. So you already got here, and then as of January 1st, 2021, you were physically present here, but you've been living already here. And then on top of it, you've been earning income during the pandemic, which they gave the date. Okay, so that's when you demonstrate that you are essential worker, and you can be part of this. And when it comes to TPS holder, again, and deferred action, they said of departure, that's for Liberian usually, has been continuously physically present in the United States not less than 3 years and was eligible for deferred enforcement departure as of January 2021 and has not engaged in conduct since that date that will render the alien eligible for deferred enforced departure. So it looks like for TPS holder or enforced departure, it is a national foreign state. Hold on, let me read this one again. Is person who has, yeah, so basically since January 1st, 2017, yeah. So for TPS holder, this is the requirement right here. Well, the person is a national or foreign state, okay, and then with a designation under subsection, which is the country has been designated on January 1st, 2017, and then notwithstanding paragraph 1A, 4, and 3C of subsection C of section 244, had or was otherwise eligible for temporary protected status under Section 2024 on that date and has not engaged in conduct since that date that will render the alien ineligible for the temporary protected status under the Section 244C2, or has been continuously physically present in the United States for not less than 3 years and was eligible for deferred enforced departure of January 2021 and has not engaged in a conduct since. So, well, in summary, for TPS holder, if you're eligible for TPS, then under section, of course, under section 244C2, you are eligible for TPS, or you are a TPS recipient, you are included, right? But that's one way to go with it. And then the other way for enforced departure, defer enforced departure, while you must have that status since January of 2021 and has not engaged in any conduct, like any criminal conduct, that will render you inadmissible. So that's what it is for TPS holders. So in conclusion, for TPS holder, basically, if you have a TPS, then you should be included. In general, so what are the crime? Well, they say this is one. If it's not inadmissible under those sections, you have not ordered, incited, assisted, or otherwise participate in persecution of somebody. If you have persecuted somebody, then you will not be eligible. If you have been convicted for any offense under federal or state law, other than the state offense for which an essential element is the alien immigration status, if your offense is just like you're unlawfully present, then that doesn't count. But if it's something else, and you have been in prison for more than 1 year, or you have 3 or more offenses under federal or state law, then you're not eligible. You can go on and on. Waiver can be available, but on the ground of humanitarian purposes or family unity, or if waiver is otherwise in the public interest. So if you have those type of convictions and you want to apply for a waiver, you're welcome to apply for it. But again, waiver are discretionary, and those are the ground on which they might grant a waiver: humanitarian purposes or family unity, or if a waiver is otherwise in the public interest. Okay, and here they talk about the way they're gonna treat expunge convictions. Limitation on removal. With respect to an alien who is in removal proceeding, this is so important, or subject to a final order of removal or an order of voluntary departure, the Secretary of Homeland Security shall provide the alien with a reasonable opportunity to apply for relief under the section. If you're in a removal proceeding or you have an order for departure, they have to give you an opportunity to apply. Okay? And you must request the opportunity to apply, or you find yourself that you are eligible. Basically, that's what they say, appeared to be prima facie eligible for such relief. If you find that you're eligible based on all the things that we're saying, well, you can go ahead and apply, or you can request the opportunity to apply. So if you find yourself in removal proceedings, and then you find that you are part of the essential workers and stuff like that. So now they're talking about stay of removal for certain children. Meet the requirement. You have to meet this requirement. Engage, enroll in early child education and all that. Then, of course, you have to be given the opportunity. Well, effective date, the section should take effect on earlier of the date that is 100 days after the date of the enactment of this section, or May 1st, 2022. So when are you going to, this is basically talking about when are we going to be eligible to apply. Well, it looks like after 180 days, really. On the date of, it says on the date of, the date that is 100 days after the date of enactment of the section. So if the laws become today, if this bill passes and becomes law today, you have to add 6 months prior to start applying, I guess, because they have to come up with applications, put the process together and stuff like that. Then people will be eligible to start applying starting May 1st, 2022. Wow, we have time, but you can still prepare. Okay. And then we have and now they're talking about a news number visa. So they increase, as far as employment base is concerned, they have increased the number. As a matter of fact, the people who have been blocked in backlog, the stuck in backlog visa, especially employment base, they will be paying super fees, $5,000 to get their green card. This basically, it's just talking about all the fees that people will be paying in order to get the green card when it comes to employment. And diversity visa too, some visa will be basically saved, even if you were prevented from entering the United States based on the proclamation. But if this bill passes, you can still go back and reclaim your visa, your diversity visa, which is really cool. And now this is where they're talking about the fees that people will be paying. If you priority date it was 2 years later, 2,500. Some people pay 5,000. Some people pay 50,000 to get a green card, which is ridiculous, but this is the way they're going to raise revenue. Okay, so that's about it, folks. I'm going to leave the link so that you can go and read it. But the main important thing is that there will be fees that need to be paid, $1,500 to be paid on top of the application fees, and certain requirement has to be met, especially when it comes to essential worker. You have to show consistent earned income from that period of time during the pandemic. For me, consistent, at least if you work for 6 months, really, that's consistent. Show income, proof of income, then we can go from there. So that is it for today. Okay, until next time, folks. Bye bye. Please go ahead and share, subscribe. Don't forget to subscribe, comment below. Let's see how this thing is progressing. We'll come back again with live session explaining until we get it right. Especially if this becomes law, I will do some live sessions just to explain things in detail. But remember that even if it becomes law today, we have 6 months before we start applying. What we'll be doing is really making sure that you have everything that you need to show proof. We hope for the best. Again, until next time, bye bye.